All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta-Palmeira, and I'm the Director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us today for Child Welfare Independent Living Programs and Eligibility. Before I introduce our speaker, I do want to go through some quick housekeeping announcements. This training is being recorded, so if you register, you're going to receive an email from Zoom within about 24 hours with a link to the recording, a link to the materials, and the CLE code. We will also be posting it on YouTube, that should be ready this afternoon. We will also update a site that I will post in the chat where you can find this training and all the upcoming trainings and all the recent trainings for this training series. This training was approved by the Florida Bar for 1.5 General CLE and 1.5 Juvenile Law Certification Credits. I'll announce that CLE code towards the end of the program. I will also drop it in the chat. It will be in the email from Zoom and it will be in the YouTube description as well. Closed captions are enabled for anybody who needs them. So if anybody's having any issues with accessibility, let me know. We will share the materials via email and a link and in the chat towards the end as well. It will also be available in the YouTube description. If anybody needs a certificate of attendance after the webinar, as usual, email me after the webinar. I usually let a few of these emails pile up and start sending these out as the emails come in. So for questions and answers, feel free to use the Q&A, preferably over the chat. If you have comments, drop in the chat. We will have a few surveys and polls during the webinar, so be on the lookout for those so you can answer them. If for whatever reason we have a lot of content today, if we may run out of time for questions, but we do have an upcoming session on August 28th that will be moderated by Robin, and we will have the opportunity to ask other children's advocates questions as well. So if you haven't registered, I'll drop that link into the chat as well, so you can register for that one. This training is being co-hosted by the Public Interest Law section, or PILS. If you're not familiar with PILS, I'll also be dropping all of that information into the chat. So without further ado, I want to pass it over to Robin.Rosenberg, the Deputy Director with Florida's Children's First, also the chair of the Children's Rights Work Group with the Public Interest Law section. So Robin, without further ado, I'm going to pass it over to you. The floor is yours.
Thank you, Jorge. And can you go ahead and publish the first poll? So welcome, everybody. I'm very excited to share this information with you. Just a little bit about Florida's Children First. We have a broad mission to advocate on behalf of and advance the rights of children and young people who are impacted primarily in the child welfare system, but also juvenile justice and the disability systems through systemic reform, education, empowering youth themselves, and promoting high quality legal representation. One of the things that we do is try to get Florida to have better laws and policies that advance the rights of children, and then help the people who have to implement those laws understand what they are, how they work, and all of you who are attending today that have impact in the system, help your understanding and your ability to support the young people that you work with. One of the ways we do that as well is through the Florida Dependency Law Center. The Florida Dependency Law Center is a free online resource for Florida attorneys and judges only. I know we have several people here who are not attorneys or judges, and unfortunately, that site is not available for you, but the Florida's Children First website is. So that's another resource for information and material for attorneys and judges. So real quickly, Jorge, can you put up the poll so folks can see who is here? What are the people who are here? Mostly attorneys, lots of GAL folks, great. Some case management, lots of other. When I was looking at the registration in advance, saw a lot of folks from different state agencies. Super excited to have all of you here. Everyone is very welcome. So for the next poll, I contemplated, and Jorge, if you could put that up, I didn't want to ask you how old you were, and I didn't want to ask you for a number of how long you've worked in the child welfare arena. So I want to ask if you remember back in the day, were you working in the child welfare arena when we had to kick out 18-year-olds because there was no support offered for them after they turned 18 in foster care? Or maybe you came in a little later when there was the Road to Independence, but it had very strict requirements about who could participate in it. Or maybe you remember when tuition exemption was limited just to undergraduates. Maybe those were taken care of, but there was no keys to independence when you started, or back in the day when relative caregiver payments were the only option to help relative caregivers. So it's just to get a sense for how long people have been working in this field. So Jorge, can you see what our answers are in this poll, please? Okay. Oh, good. So a bunch of you have been around long enough to remember when we had nothing to offer um, young adults after they turned 18. And so it sounds like from looking at this, half of you have been around for quite a while and familiar with the system. So this back in the day, I admire Seth Meyers, I have to say. I'm actually misusing it because when he reminisces about back in the day, he's reminiscing about like the good old days and the way things used to be better. But here I'm really using it for back in the day. Things were different. They weren't really necessarily better. But sometimes if you've been around for a while, you might have what was happening at that time back in the day in your head, and things have changed for the better. So, and that is really because Florida is awesome. Um, we have over the years added to the benefits, the services that we offer to young people, both while they're in care and after they turn 18. Some of our programs, we are national leaders, the keys to independence, the tuition and fee exemption, our normalcy law, national leaders among our colleagues around the state. But because it's grown over time, our independent living system is really complex. So we started at Florida's Children First with our colleagues from the Community Law Program in St. Pete and the University of Miami Children and Youth Law Clinic. Started back, I think, as early as 2012, may have been later than that, creating an independent living benefit comparison table. And this table will be in the materials that are part of the package that you will get from Zoom with the link to this training. They're available on our website. If you're a user of the Florida Dependency Law Center, they're available there. The table originally was just this PDF, and then we've created it in an Excel spreadsheet because our laws are so complicated, when you're sitting down with a young person or a caregiver for a young person, there are lots of questions and the answers to which change based on different things, like the child's status. Are they in licensed care? Are they placed with a relative? But is it in a guardianship? How old were they when they were adopted? So the table is just a static view of those things. This is just page one. There are 4 pages. It's really complicated. We did the Excel spreadsheet because if you're sitting down with a young person and say they're in licensed care now, and the proposal is to move them into a non-relative placement so that you compare columns in the Excel spreadsheet, you can hide a column so that you can just compare the two. Super complicated, but you can't do that work if you don't know the right questions to ask to get to the answers in the places you need to go to. That's really what we're going to talk about today. So, what are those eligibility conditions that you have to know the answers to before you could give advice or understand? And then, what are the things that are available to young people? So, that's the plan. That is what we are talking about today. So, I want to start all of this by saying I urge you to proceed with caution when you are looking at especially online resources for what benefits are available. And specific, and I'll point them out along the way. DCF has its main website, My Florida Families. It has My Youth Portal. It contracts with Daniel Memorial. They all have information about independent living programs that talk about eligibility. Some of them are inaccurate. Some of them are paraphrased, and some of them the law has just changed. So have that warning, caution, and even when you're using our table, which we've just updated and we think is accurate, every time I give someone an opinion, I start with the table, but then I go to the actual law, read the actual statute to make sure that someone hasn't given their gloss or interpretation. So when you're making recommendations and looking at, oh, well, let me just check this out, what are you eligible for? Make sure that it's accurate. So we're starting with the eligibility criteria, and really, I can't emphasize enough, The details really matter. You have to understand these four things when you're trying to give an opinion or help a young person make a decision. These are the things that we're going to be looking at. So the first one is placement status. We have a bunch of different ways that we talk about placement status. Out of home care is the broadest category. That includes people that are in licensed care, and it includes people that are placed by the court, by the dependency court, with a relative or non-relative. All of those people are in out of home care. Then there's permanent guardianship, hidden foster care, adopted from foster care, reunified, and emancipated. So we're going to talk about some of these in a little more detail. When the statute says you have to be in out of home care to qualify for a benefit, they mean there is an open case. The child has been placed with somebody by the court, the case remains open. Once there is a guardianship or adoption, that is a closed case. That child is no longer in out of home care. They are in the care and custody of either the guardian, reunified with the parent, with the adoptive parent, or their own self if they're emancipated. So those are the list of folks who are not in out of home care. Licensed care versus DCF custody. So all of you, half of you who are on that you remember back in the day, the terms DCF custody and licensed care were used interchangeably. And sometimes we just say DCF custody and we met every kid in licensed care. They are no longer interchangeable because when Florida created level one licensure, they made those relatives and non-relatives. They gave them the ability to get a foster parent license, level one being a child-specific license, but they didn't remove the custody from that caregiver. So right now, the kid comes in, grandma can take them, the court issues an order placing the child in the custody of that caregiver, and then the caregiver later becomes level one licensed. They are separate things now. So um, when we're talking about licensed care, and many statutes say benefit attaches to children who are in licensed care, that includes level one license. And the important thing here is to see how it is shown in FSFN, not in the physical location of the child. Because when you're talking about whether a child has accrued sufficient time in license placement, that official record, and I don't know if we're not going to call it FSFN anymore now that it's CWIS. FSFN is the Florida Safe Family Network. That's the acronym for the Electronic Child Welfare Record. So all of the records for kids related to their child welfare stay um, is uh, is now it was a SACWIS, which was a state automatic child welfare information system, and we've changed it to a CWIS. So I'm not even going to remember that acronym. Those are federal terms. So that how it used to be called Florida, it's been FSFN for a while. Basically, the state's electronic child welfare record. That's going to determine what that length, where they are in custody. So you need to find out what the electronic record says where the child was placed, and also within this, if the child is currently in the hospital, incarcerated, runaway, their custodial status is the one that they were in prior to that location. So if they were arrested from being placed with grandma and grandma wasn't licensed, they're not currently considered in licensed care. If they're arrested from a group home, then they would still be considered in licensed care. Um, it sounds picky, but it can be really important. And so the practice tip in here is to check early. Don't just presume. And often our clients don't even know. They don't know the technical legal status they were in. Get the record to find out. And if, for example, the child ran away from grandma who wasn't licensed and spent 4 months on runaway, the court can retroactively change that custodial status to a licensed status. So count your numbers and check again. And I see the questions keep coming in about FSFN, Florida Safe Families Network, which is the state's official electronic record. Okay. Um, we had the relative caregiver program, and back in the day, Florida was really light years ahead of other states We created a relative caregiver program. It was funded under TANF, Temporary Assistance for Needy Families, and the subcategory of Temporary Cash Assistance, TCA. And that's how those caregivers got money. We didn't license them, but we made sure they could tap funding so that they had some support for caring for children. And the only way they could get support was through the relative caregiver program. When we did that, the children that came in that had another funding source attached to them, those caregivers were not enrolled in the relative caregiver program. So we had children who they have an SSI benefit that comes in, it came with them. And when they came in, the caregiver was not part of the relative caregiver program because they didn't need any more money. Well, I'm sure they needed the money, but they weren't getting any more money. So if it becomes relevant and you need to make sure someone is qualified under the relative caregiver program, you need to go in and check that and have them assigned to that category. That is, I don't think really occurs anymore because now relatives can become level one licensed. And Florida really promotes that because there's a lot more federal funding for a level one license than there was for a relative caregiver program. So if you remember back in the day, that really could be an issue for access to benefits because some benefits say you only get them if you're in the relative caregiver program. So hopefully this will be less and less of an issue, but it's still one that might occur and you need to keep your eyes on. The next one I want to talk about is hidden foster care. And this is the best definition I could find of hidden foster care. But really, when this happens, is there's an investigation, there's a problem in the family, the CPI comes out, an intervention program with a community-based care lead agency comes out. You guys are a mess. Can someone in the family take care of this kid? We'll even help you get um, an, an order of temporary custody. We'll help you get a lawyer to do the forms to go to family court and get an order of temporary custody. All of that takes place outside of the official child welfare system. Chapter 39 court is never involved, and the family can miss out on a lot of support by doing that. So if you don't know, if you come across a child and they've spent the last 5 years living with their grandma after there was an investigation, and then you're trying to find out, is this child going to be eligible for free tuition? And you find out there was never any Chapter 39 involvement. Yes, the community-based care lead agency paid a lawyer to go to court for grandma to get an order of temporary custody. That is not good enough. So if you can't find out, you don't know what the status is, ask the caregiver for the copy of the order that they got. Was it issued by the dependency court or was it issued by a family court or a probate court? Or ask the caregiver, did you get more than $300 a month for caring for the child? Because pretty much if it's under 300, it's probably a welfare benefit, not a child welfare related benefit. So kids in foster care, that's a whole status to be looking out for. The next type of thing you need to know is, let's see the question. Um, there is no I'm looking at the questions in the chat. There's no statute that requires the CBC to pay for a caregiver to obtain temporary custody. They are permitted to use prevention funds to do that or other family law things. The idea being if you can help a family solve its own problems without having to pull kids into the child welfare system, that is a reasonable use of prevention funds. So there is no requirement that they do that, but there is the ability to do that. Okay, so history and licensed care, when you're kind of checking through and you're trying to find out what benefits a young person is entitled to, you're looking for all of this information. Did they have at least 6 months and licensed care? And was that time after the age of 14, before they turned 18, um, whether it was 12 months before a guardianship or adoption? Those are all details that are going to become important in a particular case. Um, did the adoption or guardianship happen before or after 14? And if it was an adoption, did it happen after May 5th, 1997? And I'll do the math soon, and someday I can drop this off being relevant in our presentation, but I think technically it's still relevant today. So when you're looking at the practice, the history and care, we have a couple of practice tips. Um, Again, check early about that time and licensed care. So you can try to get the accumulated time up to the level that is needed, and change of status orders can be entered retroactively. Lawyers, we like the term nunc pro tunc, but it just means retroactive. Um, the next area is you need to be aware of is the educational status. Has the young person completed high school or a GED? Are they currently attending either high school or college? Are they attending a GED program? And you need to find out whether they're full-time or part-time. And just keep in mind, part-time for PES is not the same as part-time that an educational institution may require. So questions to have in the back of your mind. I think there might be, let's see, one in the Q&A. How does a person determine what the FISFIN status is? That is a good question. I think if you are not a person with access to FISFIN, then you would need to ask the caseworker or the guardian ad litem to determine what it says. So, good question. Okay. Next, arena qualifying activities. This is something that we'll take a closer look at when we look at the extended foster care statute. That's when the qualifying activities were created, but they now apply to extended subsidies for adoptions and guardianship. We'll talk about them in more detail. So to just give you a quick overview of what benefits are being used now, this is a 3-year look. If you can see it, the bars, each bar is either the past 3 years, and you can see a little bit of growth in extended foster care, a little bit of reduction in time in aftercare, and a little bit of growth in PES. So that's the reported usage, the DCF reports. And overall, the last budget, the 24-25 appropriation for independent living was almost $59 million. So Florida puts a lot of money into independent living services. It's pretty awesome. Okay, so we are going to talk about what independent living services are available. The first one we're going to talk about is extended foster care, and I'm going to ask Jorge to launch the poll. This is like a little bit of a pre-test to see, here's some pretty common situations, whether you think these young people would be eligible to stay in extended foster care after they turn 18. And we're not going to show the answers yet, so you have a couple minutes to look at the poll, but let's look at what's available in extended foster care. So what is the benefit? There are 4 main categories of benefits for extended foster care. The first one is the living arrangement. So actually in the statute, which is 396251, the statute is actually called continuing care for young adults. And the concept was a continuity that we shouldn't have to kick kids out when they turn 18. If they've not finished with high school, they're not ready to be on their own, they should be able to continue where they're living. Not very practical for most people. So what are the options? There's a list of options of what can be considered a supervised living arrangement. The housing has to be acceptable to the young adult, but also approved by the CBC. So there can be a tension in here between those two things. And the requirements for what the CBC is supposed to look at for approval are listed here on the slides. And I will remind you, you will be provided a PDF with all the slides with all this information. So it's supposed to be a joint agreement. And again, when the statute was written, there was a really strong desire to allow young people to remain in their homes, their foster homes where they were, so they weren't uprooted when they turned 18. But here's where, practically speaking, where kids are living now. So that first wedge, that's kind of the light blue, are transitional living programs. There's been a big growth in them. These are entities that are specifically created for this population of young people. The second one are host homes. So these are folks who were not previously primarily we're not licensed as foster parents, but are willing to have young adults in the community come live with them. And then you see actually for licensed foster home, it's only 10%. I didn't include all of the other categories that were very small. In there were also group homes because young people can remain in their group home, but that was less than 1%. So these are the major categories of where young people are actually living right now while they're in extended foster care. The point of extended foster care, again, the continuation of care, is that it's supposed to provide all the young person's basic needs, shelter, food, clothing, transportation, all of their basic needs. Um, it's really, I think, not a promise that's always kept. We shove a lot of our young people on SNAP to pay for their food, send them to food banks. Unlike a foster home where the foster parents expected to provide 3 meals and snacks, really a lot of young people in extended foster care are much more on their own for food, and many are food insecure. They are supposed to also have an allowance. And in the extended foster care law and rules, the concept is young people need to learn how to budget and spend their money wisely. So they are supposed to have a needs assessment form. DCF standardized a form that was effective July of 2025. And the amount of allowance is supposed to be based on that needs assessment. It is for discretionary expenses. It is not to cover their main things like travel to work or to school. Travel to the mall to go shopping, non-essential, but the daily transportation needs are not supposed to be covered. So that's what they're supposed to get as far as having their life covered, room and board, essentially. They also get case management and a transition plan and a case plan that includes face-to-face contact, right? That continued support of having a case plan. There are required services that are attached to the independent living environment. These are also set out in the statute. So not necessarily that the particular apartment that they're living in is offering life skills instructions, but those services are available to a young person in extended foster care, regardless of where they're living. And then finally, for a lot of them, court jurisdiction is a really important thing. They like their judges. They like knowing that the judge is there to help hold people accountable for making sure that they get the services that they need. And while the judicial reviews are just required every 6 months, they can be requested more frequently. So kids can go to court, they can, be heard, put their issues in front of the judge. They really like that. And as far as representation goes, the guardian ad litem can continue or can be appointed. Once the young person is 18, it is at their request. If the child had a special needs attorney appointed, that representation continues past 18. Take a quick look at the chat. The very specific question about a kid in a particular situation qualifying for PES, we'll talk about and see if you can answer that question yourself after we get to the PES section. Is licensed kinship care the same as foster care? Kinship is not treated the same as kinship care. I'm not entirely sure the question, but as someone who has a level 1 license, if the child is living in a level 1 licensed home and a benefit is dependent on licensure, then it's treated the same. How that caregiver is treated and other things, that's a different story. We're talking about here are the benefits that are connected to the licensure. So I'm not sure I can answer the question any more fully. Okay, so how do you get into EFC? Florida is an opt-in state. Most states, when they created or extended their foster care program, they required young people to intentionally elect to enter into extended care. Florida did the opposite. They presume that if you're in care, you stay in care, and you have to affirmatively elect to leave. So there is no application required at 18, but they do have to enter into an extended foster care agreement. And that is in part relates to federal benefits and requirements for case management. If a young person leaves extended foster care, they can ask to be readmitted, and they can do this without limitation. If people back in the day, we had the road to independence. If you left once, you could reapply once, but that was it. There were no subsequent reentries. We know that young people, like, they're done. They think they're done. And then a few months later, they need help. They want to come back. That is developmentally appropriate. Extended foster care recognizes that, and there is no limitation on the number of times that they can leave and reenter. And in fact, the caseworkers are required to help them become eligible, to help them get back in, and in the meantime, to help them get assistance through aftercare. So take a quick look. Let me see a couple questions. Hang on. So there's a question in the Q&A about exactly what is included. I can't answer that any more specifically than I did. I'm happy to talk to you offline if there's a specific issue or situation that you want to review with me. Any amount of incarceration or charges that would disqualify them for EFC generally? No, there is no qualification related to extended foster care that touches on incarceration. They may not be able to be in extended foster care while incarcerated, but there's no preclusion, which we're going to look at the eligibility right now. What is the requirement to get into extended foster care? You had to have been in licensed care at age 18. Licensed care includes level 1, kids that were with relatives, and DCF in its rules put in youth who are not in licensed care but are in the legal custody of the department are also considered eligible for EFC. That gets your incarcerated kids. If they were in juvenile detention for 6 months before and after they turned 18, they are considered to have been in licensed care because if they went to DJJ detention from DCF, they're in DCF's custody, they're eligible for EFC. And here's my first warning sign. If you go on the DCF website or the Daniel Kids website, they will say that EFC is available to youth who turned 18 in the department's legal custody. That's a shorthand, and that's incorrect because we have our kids in licensed care in level 1 who are eligible for EFC. There's a question about assisting with room and board costs and Social Security funds. I don't have a good detailed answer for that, Heather. It is related to the needs assessment that's supposed to be done for extended foster care. And that's where it's supposed to be addressed, somewhat addressed in the, let's just leave it there. And again, happy to help work with you offline about it. It's a very complicated area, important question. So Jorge, can you pull up the poll answers for the extended foster care? Let's see what people did. All right, so for question 1, now I'm going to give you the answers. Most of you were correct. Yes, Alice in juvenile detention, picked up from the group home, definitely eligible for foster care. Brian, most of you correctly guessed. Brian was not eligible for extended foster care because he was in a guardianship. And again, you guys got it right. Cassie in a level 1 placement is eligible for EFC. So good job, everybody. Let's talk real quickly about the qualifying activities. So to be in extended foster care, you have to be doing a qualified activity or show that there's a barrier for your participation in them. The first qualifying activity is school, and that can be working in high school, GED program, vocational. The statute does not put a requirement on what attending school requires. In the administrative code, DCF says you have to be meeting the academic and attendance requirements of the school that you're in. There's a new twist for our immigrant children about school. A lot of the young adults who are in independent living attend Florida college. They have now changed their requirement for non-citizens. and will require that they show that they're lawfully present in the United States. It's not a huge part of our population, but there are many young people who are eligible for extended foster care who are immigrants who may not be citizens. And so this is not a full immigration presentation, but suffice to say that there are students who don't have a lawful status, who are lawfully present. So talk to one of your colleagues if this becomes an issue for one of your clients to show how you can prove that they are lawfully present if they want to attend a Florida college. When the qualifying activity is work, that is employment for 80 hours a month. So that's part-time. Lots of our kids have really spotty work records. So the administrative code tells folks you can go back and look at the past 90 days to see if they meet that requirement in the aggregate, if they're proving the number of hours. If they are not working part-time, 80 hours a month, they can participate in a program or activity designed to promote or eliminate barriers to employment. The DCF website shorthands this as saying participate in a job skills program. Well, that's great. If they're enrolled in a job skills program, that is definitely a program or activity, but that is not the only program activity, and that is not what the statute says. So I urge you to get creative with this. What is the barrier to them being employed? It might be that they have to do community services hours to get out of to get their license back, to be able to drive to work. What are the actual barriers, and how can you demonstrate that your kiddo is doing something to overcome those barriers? So the statute does not require a tiny little thing. Be creative to get your kids eligible. And employment can include self-employment. They're out mowing lawns, they're cutting hair. It does not have to be a job employed by somebody else. The next category is overcoming barriers to employment. Well, that's the same category as what we were just talking about. If there is an attendance requirement for the program that they're in, they have to meet those requirements. But other than that, it can be, again, very flexible. And once again, the website doesn't match the statute. The next real area is the inability to do one of the above full time. Very tricky here. The DCF website paraphrases this by saying you're unable to participate full time due to a documented disability. That is not what the law requires. The law says physical, intellectual, emotional, or psychiatric condition that limits participation. That is not the same as a documented disability. Those conditions can be a temporary condition. I can't work now because I just gave birth and I'm recovering. I was in a terrible car accident. I was physically assaulted and abused, and I'm in recovery and too traumatized to leave my house. I mean, it can be all kinds of things, and the documentation can be in any number of places for this. This is the question about documentation. Wherever you can find a record that would support that. It could be a police report. My house was broken into and I was attacked. It could be a school file documenting that you had to drop out of school because whatever occurred. Just come up with paperwork. Okay, let's see. So if a relative caregiver can't get level 1 licensed, they do not qualify for EFC. That's just it. They have to be they can move to a licensed home and qualify for EFC, but if they're not within licensed care when they turn 18, they are not eligible. Okay. It's important to know that youth can change qualifying activities. They think they're going to work, but then they're going to go to school. Case managers are supposed to help them if they need to switch. And there is, keep your eye on federal law. There's a movement to eliminate all of these criteria and to just take out qualifying activity out of the federal funding for it. Florida would have to change its statutes to go along. So something in the future. Young people leave EFC either because they reach 21 or 22 if they have a disability, if they achieve permanency, or they withdraw their permission to consent. Extending the disability, extending participation in EFC to age 22 is the only place that requires a documented disability, and the administrative code specifies where the documentation has to come from a licensed clinical professional, and it gives a whole list of professionals that can document the disability. Achieving permanency is definitely the option. Not sure if it's marriage. Definitely reunification. But a young person that goes home and then it didn't actually work out, they are eligible to return to EFC if they are no longer reunified with the parent. To withdraw consent, it has to be knowing and voluntary. If you are an attorney or guardian ad litem working with a young person and somebody gets your kid to sign a piece of paper and they didn't get a chance to talk to you about before they sign, I would argue that's not knowing and voluntary. They should have the opportunity to confer with counsel about the consequences of decisions before the decision is held against them. Kids can be terminated from extended foster care if they're not participating in a qualifying activity, they aren't staying in the place they're supposed to stay in, that you're not trapped in your extended foster care placement. You can go on vacation, you can go visit friends, but there's supposed to be something called a shared living plan that talks about how long you do that versus when you have abandoned the home. It's really important to note here that in how we balance out decision making, it is DCF's decision, not the community-based care lead agency's decision as to whether to terminate a young person from extended foster care. And again, there's a requirement to help them get back on track, to requalify, and to get them help with aftercare if they're out of EFC. And again, no limitation on the number of times that you can re-enter into extended foster care. Denial of re-entry is an appealable event. So, okay, we're zipping along. Jorge, I don't think I have a poll here. Let me just look real quick and see if there's
I'll double
any.
check. We
Don't
do
think
have
so.
some questions in the Q&A.
Yeah,
I
I'm
know a
gonna
lot of
look.
them have been coming in, so
Right. So if a youth is on runaway prior to 18, they're automatically considered to be in EFC. They have to sign an agreement to stay in, or they have to elect to leave. So yes, they would be considered an EFC. Who funds all of this? Florida funds it. The $59 million comes from both federal 4E money, federal Chafee money, and Florida general revenue money. That's where the money comes from. What happens to undocumented people who can't attend college or work authorization? They're pretty much up a creek. It's not a better answer I can't give you here today. Happy to talk to you offline if there's a specific young person that you're trying to help. Can they do a mix of activities? I think they can, Katie. I don't want to swear yes to it, but I believe they can. Can a young adult complete inpatient treatment? Absolutely, if they need to do that. And then it could be a decision as to whether where they're considered to be at that time. Completing inpatient treatment could be resolving a barrier to employment. So it depends what other benefits they're available to them. So can't say what would specifically happen, but absolutely, if they need inpatient treatment, they should do that. Okay. If the disability does not have to be documented, it does have to be, there does have to be documentation of the condition. It doesn't have to be a documented disability, and it depends what the condition is as to what kind of documentation would prove that condition. So I know that sounds like a vague answer, but I think it's the best I could do for that. Okay, let us talk about, let's see. Oh, there's some good recommendations, unpaid internships for undocumented kids. Christine Smith gave that. It's a great idea. Okay, so real quickly, extended adoption and guardianship subsidies. Like folks back in the day, we didn't have this. We have it now. the ability to continue guardianship payments up to age 21 and to provide Medicaid to young people up to age 21. If the guardianship agreement was entered after the age of 14, those young people still have to be engaged in a qualifying activity, the same as EFC, and the guardian can't get a payment at the same time as the young person gets PES. They have to elect one or the other, can't do both. Essentially the same thing for extended maintenance adoption subsidy. Important thing here, when you're thinking about those little details, the adoption assistance agreement has to be entered into after age 14. If the agreement is entered into when the kid is 13 and the adoption takes place after they're 14, technically the subsidy cannot extend to age 21. That's a huge difference for people. Pay attention when you're working at that level of detail. Okay, PES. This does have a poll. Jorge, if you will launch the poll. PES is post-secondary educational services and support. Okay, what is it? It's financial assistance. The main thing PES is $1,720 a month. That is money to the young person who are young people who are in college. If they stay with their foster parents or in a group home, they don't get the money. If they live independently, they get the money, although the CBC, we're talking about who gets the money, when they first enroll in the program, the CBC usually initially pays for the housing and the utilities, gives the difference to the young person. The concept being to transfer the responsibility to the young people so that the whole check isn't blown on the first day, that their needs are taken care of. So for those of you who remember back in the day when PES was created, young people who were adopted or went into guardianship after age 16 were eligible for PES. That number was changed to 14 in 2024. If you look at the My Youth portal and the Daniel Kids website, it still says 16. So be thinking about, were these young people, where the adoption or guardianship happened after 14? So for the eligibility, they were either in licensed care at 18, adopted from care. If they were adopted or put into guardianship, they had to have 6 months in licensed care in the 12 months before the adoption or guardianship. And again, with the guardianship now, that would be the caregiver becoming level 1 licensed and then closing the case to adoption. Everyone has to have 6 months in licensed care prior to age 18, a high school diploma or the equivalent. So admission to full-time enrollment at an eligible school. So what schools are eligible? They have to accept Florida Bright Futures. So basically, they're all Florida schools. When I say guardianship, is that guardianship is an order closing the case that is issued by a dependency judge. When I talk about guardianship, that's what I'm talking about. Eligibility goes from 18 to 22. So our young people who are done with high school and ready for college before they are 18 are not eligible to get PES until they turn 18. You have to apply for grants and scholarships, do the FAFSA, and young people have to give DCF or the CBC access to their school records. So back in the day, they used to make the young people go to their professors once a month to get the sign off on their grades. Now they give them access usually to the online portal. All right, so Jorge, let's pull up the PES answers and see how people guessed about whether young people were available. Let's look at the poll. Okay, there's a little closer split on this first one. Okay, Dwayne is eligible because he went into guardianship at age 15. Good answer. Ellen, not eligible because the Air Force Academy is in Colorado. And Colorado, the Air Force Academy does not accept Florida Bright Futures, so she cannot get PES. And let's see, Felipe, You are mostly were correct. He is not eligible because he didn't have 6 months in licensed care. Okay. So what is enrollment? Enrollment is, for PES purposes, is 9 credit hours. It can be even more, for college purposes, full-time enrollment is usually 12 or more credit hours. So this is just for PES. The PES law does not change what a college can require as a full-time student. That's not what it's about. A challenger, young people can stay on PES if they can show that they have a challenge or circumstance that prevents them having full-time attendance. This is really when somebody is enrolled full-time and then something bad happened and they need to cut their hours that semester. If they have the permission of the academic advisor, they can do that. Again, this is a divergence where the DCF website uses the term documented disability, and that is not what the law requires. So what about our young people that get into the Air Force Academy? That's really amazing, but they can't get PES. So there is something called ETV. This is a federal program. It's federal funds, education and training vouchers. And Florida gets lots of ETV money. And for many young people who get PES, the first $5,000 of the PES they get is really coming from ETV. But there is separately ETV available for young people who are in a school that is not eligible for PES or who are intentionally attending less than full time. So the annual amount for ETV is set at $5,000. The application for ETV is the same application as PES. PES is renewed annually, and you have to maintain enrollment, you have to maintain academic progress as defined by the institution, and you can stay in PES if you're making progress to restoring your eligibility. You can also leave PES and get reinstated. Again, back in the day, we couldn't do that with the Road to Independence, RTI. There was one time. Now we know young people are in and out of school. It can happen multiple times. The last application has to be before age 23. And young people can get terminated from PES if they're not in school anymore, if they're no longer a resident of the state. So we can have young people that live out of state that attend school in Florida that can access college, use the tuition exemption, which we'll talk about. But if they're not a resident of Florida, they cannot get PES. Adoption and marriage does not affect PES eligibility. Okay. Aftercare. Next main program is aftercare. What is aftercare? It is mostly services, but it is also temporary financial assistance. The services are supposed to be done based on a needs assessment. They do not have to be provided by the community-based care lead agency. They can be provided by referral. Processing requests to prevent homelessness is supposed to happen quickly, as expeditiously as possible. There should be a plan and agreement made between the young adult and YA's young adult in this case, and the CBC. They're 3-month plans, and they work toward getting to self-sufficiency, but there is no limitation on the number of 3-month plans you can have. So back in the day when aftercare was first created in 2013, the only criteria in the statute were you had to be between 18 and 23, not in extended foster care, not in PES. Well, that's great. That includes all of your children, right? So the statute didn't have any other criteria. So DCF said aftercare is only available to young people who are in licensed care at age 18. They put that in an administrative rule. That was what CBCs had to work with. That is not the law today. Aftercare has been expanded. The eligibility today is 18 to 23, not in EFC, not in PES, but except that if you're in PES, but you have an emergency, you can get temporary financial assistance. That change passed in 2021. Again, the DCF website and My Youth Portal don't mention the availability of aftercare for emergency purposes. Aftercare was expanded again in 2024 to include any young person placed in out-of-home care, remember that's our biggest category. So they were in out-of-home care, lived in out-of-home care for at least 6 months after the age of 14, and were not reunified. We have lots of young people. This was a bill that Florida Youth Shine promoted. We had lots of young people that were adopted, and then 2 months after they turned 18, that was kaput. They were done. They had no support. They had no help. They had no access to aftercare. Now, as long as they were in out-of-home care for 6 months after the age of 14, they can be eligible for aftercare. It's a big difference. Big difference. Okay, Jorge, can you put up the answers to the aftercare poll, please?
I guess I
Okay.
need to put the questions up first.
Oh, we didn't do the questions.
Yeah.
You know what?
Yeah, I was
We're
like
gonna
waiting for the prompt.
I'm so sorry. We're going to skip over that. And
Okay.
I will just show you really quickly. Someone who was placed with a relative for 3 years before being adopted at 16, eligible because they had 6 months after the age of 14. Um, Pests with an emergency repair and reunification. A kid who spent 6 years in foster care but reunified at 17, not eligible. Okay. Tuition and fee exemption. You could go ahead and put the poll up for that. Thank you. Let's talk about that. So what is tuition and fee exemption? Um, let me switch the things while we're talking. What's included? Tuition and fees related to attendance. So lab fees, application fee, does not cover your parking fee. It does not cover housing, a dorm, or food fees, but fees related to enrollment. It is not limited to undergraduate classes anymore. It can include any education offered by the school up until age 28. So that means if you can go get a master's, a PhD, go to law school, all of that is covered. The important thing here to keep in mind is there are a lot of things that are sort of penalties. Sometimes our young people have to take the same class 2 or 3 times. There's an additional fee if you have to repeat a class. That is a fee that is exempt. If you take more, they only want you to take 120 classes to get to undergraduate, but you can't be done then. You have to take more. That fee is waived. If you were adopted and moved out of state and you move back to Florida to go to college, you have to pay the non-resident differential. That fee is waived. So if it's a tuition-related fee, it's covered. The schools that accept the exemption are Florida's public colleges and universities. And then the school districts have a lot of workforce education programs that are covered. And like I said, goes to age 28. It is super awesome. So if you remember, those of you who remember back in the day, there were a bunch of people who were not eligible for tuition and fee exemption that are now eligible. So the only category that still remains are kids who were adopted prior to May 5th, 1997. So what's the eligibility? They've revised the eligibility to say students that were the subject of a shelter, dependency, or TPR proceeding. Sometimes we had kids in shelter status for a long time whose case never got adjudicated. If they were in a proceeding, if they were in out-of-home care now, like our 17-year-old that's ready to go to college now, or were in out-of-home care when they turned 18, adopted after May 5th, 1997, reunified, this is a new category, reunified between the ages of 14 and 18, so long as they spent 18 months in out-of-home care, the broad category. And then the guardianship provisions in the statute are all kinds of messed up. It says it's 7 which ways from Sunday, but pretty much I don't think there's any kid who's in a guardianship who would not be eligible for tuition and fee exemption. If you get somebody trying to reject you for it, talk to me and we'll work through there's several different parts of the statute where that is detailed. Okay, so can you pull up the poll answers, please, Jorge? Let us see how people did. Okay, let's see. Not eligible, right? Because the order of temporary custody didn't go through the child welfare system. So that child was never considered part of a Chapter 39 case. The second one, you guys were a little closer, and on that, Kyle was eligible despite being reunified because he had the time and care after the age of 14 and or time and care period. And let's see. Oh, so this is the first one where more of you got this wrong than got it right. The University of Tampa doesn't accept the tuition exemption. It's not a public school. So wasn't trying to trick you. All right. Thanks, everybody. There is a couple other things I wanted to mention and with regard to this. The the public schools are supposed to have a campus liaison. Every college, state college, and university is supposed to have a person who is knowledgeable, accessible, and responsive to students. They should have some guidance and some help. The subsequent request for eligibility documentation, again, back in the day, when a young person, they'd get the tuition exemption for the freshman year, and they'd go back ready to go sophomore year and be told, you didn't submit your tuition exemption. Once the school has it, they cannot ask you for it again. Eligibility does not change for this category. If you change schools, you have to submit it to the new school. And the schools may provide campus coaches. So I'm going to catch a question here. If a student failed and retakes, the tuition exemption does cover the cost of retaking the class, and it covers if the school tries to charge a fee. I think the fees come in when they take it a third time. So like, the first time it's whatever, $500. The second time it's $500. The third time it's $750 because they tack on a fee. All of that tuition is exempt for a student who gets this exemption. I'm sorry if I made it sound like something else. Okay. I know we're cooking along. Jorge, can you launch the poll for Medicaid? And let me look at the Q&A. Where's the Q&A? Bright Futures lets you use your scholarship toward private school. So is there any thought of using it tuition exemption for former foster youth? And the answer to that is no, because the tuition exemption isn't actually any money. The tuition exemption is the legislature and the governor telling the universities, you can't collect money from a student, but the schools do not actually get any money. So in Bright Futures, there's an amount of money that is provided from the Bright Futures pot to the institution. With the tuition exemption, it's just the law saying you're exempt from having to pay. So unfortunately, it will not be translated over to other schools. Okay, Medicaid can be surprisingly complicated. So just the basics of Medicaid, EPSDT, we can have a whole separate conversation about, but EPSDT is the type of care that Medicaid providers have to give to children up to age 21. It's very comprehensive. It includes dental, it includes eye, anything needed to correct or ameliorate a known problem is covered under EPSDT. Early periodic screening, diagnosis, and treatment. That's what that acronym is for. Okay. When you turn 21, you go to the adult state plan Medicaid, which is very different and less coverage. Okay. Eligibility. Young adults in extended foster care and eligible for PES or aftercare are covered under this particular statute to age 21. That existed before 2014. In 2014, we passed Affordable Care Act, sometimes known as Obamacare, which said that the states had to offer Medicaid up to age 26 for young adults who were in out-of-home care in Florida when they turned 18 and were on Medicaid at that time. It does not require that they've been on licensed placement. The federal term is foster care, but it incorporates everything that we call out-of-home care. So that Medicaid to 26 is anybody that had an open case and was on Medicaid at that time. But starting at age 21, you'd have to apply and do the renewal steps every year. This is where there's a cliff. This is where we see young people just drop off the face of the planet. They didn't know they had to apply. They show up at the hospital a year later and they found out they didn't have Medicaid because they didn't do the renewal process. It's very challenging. Medicaid to 26 is portable between states. So young people that come from another state, they were in foster care wherever they lived before, they are entitled to Medicaid in Florida until age 26. There is a chunk of people who aren't going to get it to 26 who will get it to age 21. And that's the young people eligible for PES or aftercare. So they may have been in a closed case when they turned 18. So they don't get it to 26, but they get it to 21. And that includes now young people who are eligible for EMAS or EGAP, extended maintenance, adoption, subsidy, and guardianship assistance program. But Medicaid ends at age 18 for this set of population. If they were adopted or put into guardianship before January 2019, or their guardianship adoption agreement was dated before their 14th birthday. So we have lots of young people who were adopted from care, put into guardianship, they get Medicaid till 18, and then it goes away. It's really challenging for families. Okay, Jorge, can we look at the answers to this question, please? All right, let's see what you guys said. Okay. Yes, you were right. Mark in an open case is eligible for Medicaid. Nina is not eligible for Medicaid because her guardianship closed before she turned 14. And Otto came from Georgia. Yeah, this was a split because Florida did not affirmatively elect to give Medicaid to students from to people from out of state, but the federal law now requires it. So, all right, let's talk about keys to independence. And I don't think we don't have a poll on this. This is another benefit that's available to young people. Let me just double check. So Mary asked about can tuition exemption, I guess we're back up at tuition exemption, be used for a welding course? If a welding course is offered by your local school district, there's an adult education vocational program that's offering the welding course, the tuition exemption is available for that. If it's a private academy or private trade school, the tuition exemption isn't available for that. But it's a good question. All right, keys to independence. Another place where Florida is really ahead of the nation. There's some proposed federal legislation. Everybody looks to Florida about how we did it. It's really something that we should be proud of. What does it do? It pays for the expenses related to licensure for driver's licenses, and it offers some assistance with paying for insurance, which is huge because people don't want to have licensed drivers in their house if they can't afford the insurance that goes along with it. So what does it actually cover? If you go to the Keys to Independence FL.com website, this is their list of fees that they will pay up to. So that's the funding for financial coverage for it. Who is eligible? So youth who are in out-of-home care from age 15 to 21. So you can get as soon as you can get your learner's permit, and those who are still in extended foster care. Young people who are receiving PES, so between 18 and 23. Keys is now open to certified unaccompanied homeless youth, ages 16 to 24. And it's intended for people in open cases, but if you're in an open case and achieve permanency, you have 6 months after reaching permanency or turning 18 to continue the enrollment. So if you're in it and then get that permanency, then it ends. Then you have 6 months to continue on with it. New thing is Step into Success internships. These were created as a pilot a few years ago. There's no real website for them, but you can email DCF at this email address. It is a paid internship. So I think the proponents of this law really looked at how Florida offered support to young people and said, we're doing a great job supporting young people with higher education. We support them finishing high school with extended foster care. We support them in college with PES. But some people are not cut out for college. That's not the path they want to take. We want to support them in work. How do we support them in work? So they created a pilot project for Step into Success that creates a paid internship program. They have to work a minimum of 80 hours a month. They get a cash stipend. The stipend amount was recently increased over from the pilot was so successful that the legislature put it into statute and increased the monthly stipend. The stipend can be paid for a maximum of 12 months. There's an additional clothing stipend for clothing to be purchased that's appropriate for work attire. There can be post-secondary credit if a student is also enrolled in school and their school offers internship credits. I think one of the next two parts are also really awesome benefits. Workplace mentorship. So they actually require the employer to designate an employee to be the mentor. That mentor has to take specific training, including training on trauma, so they know the population. Yes, Step into Success can be used alongside PES. And I'll get to the keys question in a little bit. The mentors, there's some compensation for mentors. They treat this as really a serious thing. Like, we want people to succeed in the workplace. They need to have someone alongside them to help make sure that happens. So that's a major feature of the program. And then also the professionalism and workforce education, just even before they get into an internship, being prepared for work, resumes, dealing with people in the workplace. It's really geared to helping young people succeed in employment. When it started, the pilot locations were Central Florida and Northwest Florida. And in the statute, the expansion locations are listed here on the slide. That is where they are recruiting employers. I don't think that there is a limitation on doing them in other places, but I also don't think there's any effort to expand to those other places. So, good question about that, but those are the locations that it's intended to do. The eligibility for Step into Success, this is one place where the law specifically says it is for young people in licensed care, but not level 1 licensed care. So the kids that are living with a relative who got a license are not eligible for the Step into Success program. The professionalism part starts at age 16. The internship part, you can't get the job until you're 18. And you had to have been in licensed care for at least 60 days. So that's an interesting tweak on eligibility. I'm going to go back and is Keys to Independence available to people placed out of state through ICPC? I don't know the answer to that question, Stephanie. I think you'll have to check with the Keys folks. I'm not sure. I just don't know what the statute says. Okay. Next arena, college and housing benefits. This is kind of a new to us, not really the formal programs that have been created by the state, but there's some important things that you need to know about. So access to housing is critical for all young people. And Florida Youth Shine specifically advocated for improvements in the housing arena with the legislature a couple of years ago, and were successful in having a bill passed. Part of it requires that the campuses, so this is our public colleges and universities, if they don't already have a plan to prioritize foster youth, they're supposed to create a plan to prioritize foster and homeless youth in campus housing. And if they have a priority assignment system already in place, they have to put those young people in the first priority. And that's both for housing and work study. So if there's an existing prioritization program. And the other component on the campus housing is they can't require students to have a cosigner or guarantor to get into housing, to get into college supported housing. So it's intended to ease the path for existing campus housing options for young people. Outside of campus housing, the law addressed the Foster Youth to Independence federal housing vouchers. FYI, vouchers are a form of Section 8 housing voucher under Housing and Urban Development, HUD voucher. And the statute requires DCF, the CBCs, and public housing authorities to work together to make FYI vouchers available to students to young people, former foster youth, not limited to students, to former foster youth around the state, and encourages them to take the steps that are required to make FYI vouchers are available. I will tell you the voucher program is a priority of the Trump administration and of the Housing and Urban Development Department. There is plenty of money in there, and there is a push of urgency to make those vouchers available to young people. Pockets of Florida do really well with this, and other parts of the state are really lagging behind. But the option is there, and it's a great place to advocate locally if you have young people who are not housed. Also in that same bill, the law requires that the CBCs and entities serving youth and EFC, PES, and aftercare take steps to help get people into residential leases. So we know the young people tell us they have a hard time in the private housing market if they don't have a cosigner or guarantor. Short of telling the CBCs they have to co-sign for a lease, they have to at least document what they're doing to facilitate access to residential leases. And then, as I mentioned, the Housing Choice Voucher has been renamed the Melania Trump Foster Youth to Independent Housing Vouchers. And those vouchers are available for 3 years with a additional 2 years possible. There's the age requirements, and you have to have formerly been in foster care. So young people who were never in that, we say foster care, that'll be the broad out-of-home care, not the specific category of licensed or not, and at risk of becoming homeless. So, so the question about no FYI vouchers available in Miami-Dade or Hialeah. So technically, no, that is not true, because there is an unlimited amount of housing vouchers. They can be obtained upon demand. The issue that happens at a local level are decisions that are made. Many of the Florida housing authorities say we can't access FYI vouchers until we've handed out all of our FUP vouchers. Those are Family Unification Program vouchers. So there are tons of implementation problems at the local level, but technically there's an unlimited number of vouchers that are available. So, and we would love to talk to you more about issues that you're facing in whatever locality. So you're understanding that if a young adult gets a housing voucher, they don't qualify for EFC. If to the extent that EFC is paying for the housing, that would be sort of double counting. I don't know. I'd really like to talk to you about that. I have not heard that was an issue before. So Stephanie, let's talk about that sometime, of what the situation is. I would really super duper encourage you, if you have a kid who's in EFC, a young adult, to wait to try to get an FYI voucher until their EFC is over. Like, don't get them an FYI voucher when they're 18 and have 2 or possibly 5 years of housing assistance. Wait till they're 21 and then get them 2 or possibly 5 years of housing assistance. Those are choices that should be made. So, and Ruth, who has lots of experience with FYI, is mentioning that it's double dipping. Okay, so talked about a ton of things, and I did it pretty quickly. You have all the materials with you. I am going to stop sharing this screen, and I'm going to show you something else that is super duper cool. I'm going to give you a sneak preview of a new tool. So this is not available for use yet, but we are working with the University of Miami Children and Youth Law Clinic on a new website that will be interactive, that will help you figure out in your specific situation what you're entitled to now, and if your situation changes, what you would be entitled to in the future. So this is a sneak peek at the website. So you can do an independent living check. How old are you right now? I'm 19. I was adopted after 14. I spent 6 months in licensed care. I'm a Florida resident and I've attained my GED. I'm in school part-time at a Florida institution. I don't have a disability. I just prefer to go part-time. And then it will tell me, nope, not eligible for extended foster care. Pretty close to being eligible for PES. I'm a step away. Here's why you're not eligible for aftercare support. So it's super complicated. All of these things are super complicated, and we are taking our time to make sure that everything is accurate. That's why we're not showing it to you until it's really ready to go. But the best kind of, I don't know, one of the coolest things, it's all very cool to me, is the what happens if part of this. So I'm going to tell you where I am right now. I'm 17 years old. I live in a licensed group home, and I have been in licensed care for, I don't know, 14 months. And I'm considering moving into permanent guardianship. So what's going to change? Well, if I move into permanent guardianship, I'm not going to be eligible for extended foster care anymore. PES thinks it's maybe a little bit at risk. ETV, it depends on the facts. So this is just, it's a lot of work. It's really cool. And as soon as it's ready for prime time, we will share it with you. But in the meantime, you have our great chart, both the PDF and the Excel spreadsheet. So, okay, let me just look and see if there are any, see lots of nice notes. Are there any questions that I've missed? And as Jorge told you previously, on Friday, August 28th, we're going to have a panel of all of my colleagues at Florida's Children First available to answer any of the questions that you ask that we're capable of answering. And so we hope you'll join us for, and in that conversation, we'll not be in webinar mode. We'll be able to see each other and ask questions and talk to each other and share your expertise with your colleagues as well. So, Jorge, did I miss any questions that you saw?
Don't see any pending questions. I have to say the chat is similar to my earlier reaction when you showed me the website, so there's a lot of excitement about it.
Yeah.
In the chat, I dropped the CLE code for the webinar. I'll read it out loud. It's 26082005N. I will also email it. It will also be in the YouTube description. If anybody needs a certificate, you can email me afterwards. I also dropped a link to the materials, not only for the slides, but some other materials that Robin shared. I'm dropping the link again. I'm also dropping the link to the website that I have set up on the Pills site. On that page, you will always find the next webinar, the next few webinars that you can register for, and also a list of recent webinars for this series. So I don't see any questions yet. So I see a lot of thank yous, Robin. Amazing presentation as always. I will drop my email in the chat here.
Yeah, and we are always happy to take questions offline. You have our email address. Let's see, something came in on the Q&A. Does someone automatically talk through the opportunities with caregivers and children? I wish I could say yes, that happens all the time. But I'm afraid the answer is no, that it doesn't happen all the time. So the child's case manager is supposed to talk to them about their opportunities, about the programs that's required by statute. It's part of 394085. And the requirement of educating young people about their rights, that's included in that. Uh, these things are very complicated. They're complicated for lawyers, and I don't want caseworkers giving legal advice. So I really hope that attorneys and guardians ad litem will use these resource materials to look very carefully at the law and eligibility, that judges will encourage people to get good advice on things. Super duper encourage attorneys that are doing adoptions and guardianships. And I mean, we do this presentation every so many years. The last time I did it, I had a guardian ad litem call me totally freaked out because they had just recommended this case closed to guardianship and at a time at which children were going to lose significant benefits. And, she was freaked out because she thought she was doing the right thing by promoting the guardianship, and she now realized all the things that kids were going to lose. And so we were able to talk through what she could do to stop the process, to get a rethink and make sure that the timing wasn't going to really screw over the kids. So, it's too many people can't know about this. Too many people can't be asking about it. So the more you know, the more you can help other people get to good places with this. So
Robin, I did open up the poll for any other, if anybody has any other trainings or subjects that you would like us to do training on. I opened up that poll. If for whatever reason you miss it, feel free to email us and we'll kind of add it to that wish list as well.
yeah. Thanks everybody.
All right. Well, thank you everybody for joining us. Have a great rest of your day. Thank you again, Robin, and we'll see you at the next one.
Take care, everybody. Bye-bye.